I'm going to call the Jobs and Economic Development and all the others that are listed in this particular conference committee to order. Good morning, or good afternoon. It's nice to see everyone again. We haven't seen each other since Thursday or Friday. I can't remember anymore. So I think today what we're going to go over is we're going to have Commissioner Kelly address the committee about the commerce issues and see what comes from that. So if Commissioner Kelly could step on down, please.
Mr. Chairman, I hope only good things come from my spending some time with you this afternoon. Thank you for giving me some of your time. I'm Steve Kelly. I am the Commissioner of the Minnesota Department of Commerce. Excuse me, I'm still recovering a little bit from a cold. First, I thank you, Chair Mahoney and Chair Pratt, for the opportunity to talk with you today, and also for the I know, though, you took some time off. There has been a lot of hard work by members of the conference committee, and I know that there will be continued hard work over the next, hopefully, only 4 days while we try to solve the challenges in front of us. Thank you to the House for including the governor's budget recommendations in their omnibus bill, and I hope that the Senate will see its way clear to adopting those provisions. Specifically, thank you to the House for including the operating budget adjustment to support the core functions of the Department of Commerce. As I may have mentioned to some of you before, Commerce was the only agency that did not receive any operating budget increase in the previous biennium. Commerce's impact across the state of Minnesota is broad and deep. Every day we take actions to protect consumers. We're alongside Minnesotans as they shop for insurance, pay their energy bills, avoid fraud and scams, buy deli meats at the grocery store, pump gas, and many other activities in their day-to-day lives. In order to maintain the quality of our work on behalf of Minnesotans, we require state investment in our core operations and infrastructure. We operate efficiently, but each year the cost of doing business rises. Employer-paid health care contributions, pension contributions, FICA, Medicare, along with other salary and compensation-related costs increase, and our rent also goes up. We are requesting bare minimum in funding. This change item is needed to maintain the mission of the department and its delivery of current services, including stabilizing our basic infrastructure, covering costs for salary and rent increases, addressing consumer and business concerns and inquiries, processing license applications and renewals, and filling open positions that enable us to do all of those things and continue our outreach efforts around the state. The House also included our request for litigation costs for both the Safe Flight case and the lawsuit filed by the state of North Dakota. Just as a reminder for members who may have heard about one or the other, depending on which committee you served on in your body, the Safe Flight case stems from a 2015 lawsuit involving the department. The district court ruled in a mixed ruling for both the department and the opposing party. We were ordered to pay a reduced amount of attorney's fees and costs as part of that judgment. In January of 2019, the Court of Appeals affirmed the district court's decision awarding the plaintiffs the reduced amount of attorney's fees plus interest. That amount totals $960,000, which we must pay by July 1st, 2019. The second litigation item relates to a lawsuit filed by the state of North Dakota against Minnesota's Next Generation Energy Act, which was passed by the legislature in 2007. In August of 2018, the Public Utilities Commission and Commerce entered into a payment agreement with the state of North Dakota and the other private parties to pay the attorney's fees and costs judgment. The Commission and Commerce have made an initial payment of $360,000 towards the judgment. There's an outstanding balance of $1,050,000. A portion of half of that is the responsibility of the Commission, and the other half is the Commerce Department's. The department entered into these battles on behalf of Minnesota law and Minnesota consumers. and the costs we incurred are part of the necessary process of doing our work. These appropriations are needed to pay the court-ordered legal fees without compromising our core mission activities. Also in front of you is our provisions related to the department's unclaimed property operations. We appreciate that the House has carried our requested unclaimed property policy changes. The department's unclaimed property program is a lost and found that reunites Minnesotans with money that somewhere along the way they lost track of or that went missing. Minnesotans are the true beneficiaries of this program. Last year, we returned over $31 million in property to consumers. The unclaimed property program is growing, but needs modernization through policy changes and an operating system upgrade in order to better serve Minnesotans. The current unclaimed property law was first enacted in 1969 and has seen only modest revisions since. The law is out of date, does not reflect 21st century business practices or current financial instruments, and makes it harder for Minnesotans to claim their property and for Minnesota businesses to be in compliance with the law. Together, through policy changes, we'll increase the number of claims the department can process for consumers, account for modern and specialized financial products, and improve our partnerships with the businesses that end up holding unclaimed property. This increases both the amount of property turned over to the state in compliance with state law and the amount of property returned to Minnesotans. Over the long term, failure to modernize Minnesota's unclaimed property law and to provide a new operating system that supports our activities will erode our ability to administer the unclaimed property program. The governor's budget contains funding for additional staff to increase the number of claims the department can process for consumers, account for these modern and specialized financial products, and improve our partnerships with business. The policy also creates a uniform standard for how the state handles claims paid to consumers that were reported as interest-bearing, bringing Minnesota law into conformity with a court decision last year. Commerce has been committed to working with stakeholders on this project to try to find consensus items as we move forward. We know it's complicated, and we want to make sure that we get it right. The House also included the other provisions of the governor's budget that I will touch on only briefly. We have a request for system modernization in a couple databases and also in some public-facing filing and docketing systems. I already mentioned our need for an upgrade to our unclaimed property system. We also, in order to continue our efforts related to grid reliability and interactions with a variety of external stakeholders, are requesting a reliability assessment of $500,000 that provides funding for the work of our Energy Regulation and Planning Unit. Both the House and the Senate provided funding for solar on schools. We see that as a positive, and both the House and the Senate provided funding for making the Prairie Island Indian Communities net zero project possible. The department does have concerns with a couple provisions in the Senate position beyond not including many of the governor's budget recommendations. One of those is the financial institutions cap. The department has concerns about capping our ability to do assessments in the financial institutions area. This would have a harmful effect on the ability of the department to regulate state chartered banks, credit unions, as well as other financial institutions and safeguard Minnesota consumers. Relative to other state financial regulators, the Minnesota Department of Commerce is very efficient. While this allows us to regulate many industries and companies with a smaller staff and lower costs of the industry, it does limit our ability to respond to financial crises or changing business practices. And the ability to do assessments provides us that flexibility. For example, the financial recession of 2008 caused substantial stress to the state chartered banking system. If Commerce was not able to increase the assessment, it would have left state chartered banks under the exclusive control of federal regulators and limited our ability to be a resource for the industry when they needed it most. With the ability to increase staffing during that period, Commerce was able to work with state banks to create and monitor improvement plans, helping roughly 110 problem banks get back to a healthy condition. Financial risk is not limited to an economic downturn. The size and complexity of financial institutions can change dramatically, resulting in new risks that should be monitored closely. While banks and credit unions are relatively stable, non-depository institutions have grown substantially over the last 10 years. Additionally, the vast majority of operating costs are employee-related expenses. If the assessment is capped, subsequent increases in staffing costs dictated by a negotiated contract will likely have to be offset by reducing staffing levels. Commerce does not plan to add staffing to bank and credit union regulation other than replacing departing employees. Since our financial institutions division is already operating with a relatively low level of staffing, any reductions imposed by a cap on the assessments would have a significant impact on turnaround time and the degree of regulatory supervision that we can provide. The Senate position also cuts the department's funding for the Conservation Improvement Program almost in half. We think there was some confusion over the sunset of some language previously that directed the department to use $400,000 of the total $850,000 assessment that we have been levying for the electronic reporting and tracking system that utilities use in connection with the SIP program. Although the language related to that $400,000 sunset, we continued to receive the $850,000, and the Senate proposal would cut $400,000 from that number without changing the expectations for activities. And so we have continued to support that electronic reporting and tracking system even without the language that had directed us to engage in that activity. Having the SIP budget will effectively take away the technical assistance and computer software that our utilities rely on to run their SIP programs. The Department of Commerce oversees SIP to ensure that electric and gas utility programs save homeowners and businesses money and energy. As most of you know, the SIP program is one of the most successful energy programs in our state history, saving Minnesotans more than $6 billion in utility bills over the last 20 years, which amounts of hundreds of millions of savings in each year. Eliminating this funding will significantly affect Commerce's ability to ensure the continued success of SIP. We look forward to continuing to work with this committee and stakeholders as the provisions of the Omnibus bill progress. Mr. Chairman, my comments today were specific to the budget items contained in the Omnibus bills. I would be happy to also discuss some of the policy items, specifically in the energy-related area, if the committee would like to do so. Otherwise, I would be happy to take questions at this point.
Are there any questions? Senator Dahms.
Thank you, Chair Mahoney. Commissioner, on the unclaimed property, can you tell me how many FTEs you plan on adding there, or that you're requesting?
Commissioner Kelly.
Mr. Chairman, my recollection is that we are requesting 4 in the first year and an additional 3 in the second year.
Senator Dahms.
Follow up. It's my understanding that you feel the folks that you're putting out in the field to look for unclaimed property. It's my understanding you figure there'll be about a 5 to 1 return. For every dollar you spend, there'll be about $5 of return on unclaimed property. Is that still the figure that you folks are still using?
Commissioner Kelly.
Mr. Chairman, Senator Dahms, I don't have that spreadsheet in front of me, but that sounds like it is in the range of numbers that we discussed.
Follow up.
Go right ahead, Senator.
I understand that, well, I kind of look at this unclaimed property as 3 different parts. The part where you're talking about hiring the additional staff, and then the amount of money that MMB is allowing you to book for that, and then also the actual language that deals with the unclaimed property and how that'll be handled and looking for the unclaimed property and what happens once you find it, and how the insurance companies and how the banks and how the annuity companies and those folks will play into this. I understand that piece, and then also the third piece, as I look at, is the hall issue, where to allow you to pay interest, we're going to have to pass that portion of the language. Can you tell me, I know that on the second part where you're dealing with the stakeholders and stuff, it's my understanding that you folks have agreed to, on that piece of the policy, to kind of let that go until you have this worked out with the stakeholders. Could you tell me how that's coming with the stakeholders?
Commissioner Kelly.
Mr. Chairman, Senator Dahms, earlier this week, one of the requests we had received was to incorporate the draft bill language into existing law so that it would be easier for stakeholders to see the effect of the new language with existing law. We prepared that draft and sent it out to our stakeholders earlier this week, and my understanding is that we've received some feedback identifying that with respect to some stakeholders there may be one or two issues left, and then potentially some technical drafting issues. And so my sense is that stakeholder conversation is proceeding quite well, and I can guess, Mr. Chairman and Senator Dahms, that based on my past experience that it is entirely possible that we could achieve consensus with those stakeholders before the close of the session.
Follow up, Mr. Chairman.
Go right ahead, Senator.
Is this the only request you've had from the stakeholders, the one you said you just got in within the last week or two? Is that the only request you've had?
Oh, Mr. Chairman and Senator Dahms, no, we've had previous requests related to earlier conversations, and my understanding is that the draft we shared incorporated our responses to some of the earlier concerns that had been expressed as part of our efforts to move towards consensus.
Senator Dahms.
Have you been receiving many complaints about the way the unclaimed property is currently being handled under current law?
Commissioner Kelly.
Mr. Chairman, Senator Dahms, I do not have the statistics on whether we have received complaints.
Follow up, Mr. Chair.
Senator.
Thank you, Mr. Chair. And Commissioner, it's my understanding that this language is kind of being put together after the Illinois language. Is that correct, or have I been given some bad information?
Commissioner.
Mr. Chairman and Senator Dahms, my understanding from the team that's been working on this for some time is that they have looked at the Illinois law, but also have looked at the uniform model law language, uniform law language, and that our effort in developing our proposal was to have a Minnesota version that built on both the Illinois language and the model language.
Senator Dahms.
Thank you, Commissioner, and I would really urge that we go forward making sure that we do have the stakeholders and the department on the same page. There are other states that have implemented language similar to this, and they didn't go through a very good process of vetting this, and now they have several bills in front of their legislatures this year trying to straighten it out, in some cases trying to appeal it. So I would hope, repeal it, but so I would hope that we, even if it takes more time than this session, that we would take the time to do it right so that when we get it done, we don't have a bunch of issues we're coming back and trying to correct. So thank you for being here, and thank you for answering my questions. I do appreciate it. Thank you, Mr. Chair.
Senator Osmek.
Thank you, Mr. Chair. Commissioner Kelly, you mentioned the $400,000 assessment. I guess I'm a little confused. The section of statute 416B.241 subsection 1D specifically has a sunset on that $400,000 assessment. Could you explain, if the $400 assessment is no longer needed according to statute, could you explain why the department believes they should be refunding that $400,000 someplace else?
Commissioner Kelly.
Mr. Chairman and Senator Osmek, my understanding, and I don't have that language in front of me, is that the sunset was on the direction about how we spend that money and was not a sunset on the actual assessment. The new language that is in the Senate position, as I understand it, does take away that $400,000. So the activity that we've been using that money for continues and continues to be valuable both to the department and to the utilities that have to comply with the SIP program. And so taking away the $400,000, the actual money, this time as opposed to sunsetting the directive language, means that we could not continue to maintain that computer program and supporting activities that the utilities use in reporting their SIP activities to the department.
Osmek.
Thank you, Mr. Chair. So, keep saying it. Commissioner Kelly, what technical assistance are the utilities getting then if by chance the Senate decided to fund that $400,000? What technical assistance are they getting? Because in the subsection that we're deleting, it was, in my read of this, build out of and maintenance of what services are going to be rendered if that $400,000 is going to be granted.
Commissioner Kelly.
Mr. Chairman and Senator Osmek, the department maintains a software-based reporting system and then consults with the utilities on their reporting under that system and other activities related to questions they may have about their activities under the SIP program. So the support we provide is maintaining this software system that they can use for reporting their activities more efficiently than doing it through other methods.
Senator Osmek.
Thank you, Mr. Chair. So, Commissioner Kelly, how many hours a month then is there technical operations or maintenance being done on that facility or on that system? When you build a system, you build it, and because laws have not necessarily been changing in SIP, although I'll ask about that here in a few minutes, there's not a lot of additional programming that I could see, and I come from that area. Can you tell me how many do you have a full FTE or 2 FTEs, or what exactly is being expended on maintaining that system?
Mr. Chairman, I don't know the answer to that question about how many FTEs, but we can, Deputy Commissioner Sullivan can respond to that question.
Deputy Commissioner Sullivan.
Chair Mahoney, Senator Osmek, the cost of the program is $400,000. So it is literally the cost of the program to run the program to make sure that conservation is accounted for in a consistent, uniform way across the state. So that the price of the program is $400,000.
Senator Osmek.
So you're continuing, basically, you're continuing something that's been sunsetted. I guess if this system is not being sunsetted, why do we have a sunset on it? Do we have to maintain and actually remove the sunset or leave the statutory language in place? Is that what's required?
Mr. Chairman, Senator Osmek,
Kelly.
the department did not oppose the previous sunset on the language telling us what to do with respect to the assessment because we were continuing to receive the assessment and carry out the activities that assessment enabled, including the program that Deputy Commissioner Sullivan mentioned. It operates statewide. And that activity is not just the software program, but also the people who work with the utilities related to that software program.
Senator.
Thank you, Commissioner. I have a question on SIP, Commissioner. Currently, I believe the Department of Commerce or the Governor's Office is working with stakeholders on some SIP language and modification, perhaps to what the House or the Senate currently has in this omnibus bill. Can you give me any kind of a status update on what's happening with that SIP language?
Commissioner Kelly.
Mr. Chairman and Senator Osmek, we've continued to talk with all of the stakeholders in the energy area related to the governor's proposals and their concerns about language on both the House side and the Senate side, specifically related to conservation improvement. We have talked about the issues that the municipal utilities and the cooperative utilities have with respect to the governor's proposal. We've identified concerns that they have, and we are continuing to talk about ways to meet those concerns.
Senator Osmek.
Thank you, Mr. Chair. Well, certainly, Commissioner Kelly, it'd be nice to have that in this bill. If it's not ready for prime time, maybe it's for next year's legislative session. My last question has to do with the appeal of line 3. Commissioner, my understanding is that let me have you state it. Can you please explain the department's position on the line 3 appeal, please?
Commissioner Kelly.
Mr. Chairman and Senator Osmek, we have filed an appeal from the Public Utilities Commission final order to the Minnesota Court of Appeals, and our position in that appeal, as it has been since before I started this job, is that state law requires an applicant for a certificate of need to submit a forward-looking demand forecast, and that that in this case the applicant did not submit a forward-looking demand forecast and therefore was not in compliance with state law regarding a certificate of need.
Senator Osmek.
Thank you, Mr. Chair. So, Commissioner Kelly, was that not part of the original statement and documentation that was provided to the PUC when they were adjudicating this case back in June? Was that already brought to their attention?
Commissioner Kelly.
Mr. Chairman and Senator Osmek, it was brought to their attention in the proceedings before them.
Senator Osmek.
So, last question. So, Commissioner Kelly, if this was already put in front of the commission already knew of your complaint, the commission did not request that, and now you were appealing something that was already in the documentation, do you think that that's a proper use of the commission or the department, and that they should be appealing something that the PUC clearly, by your own words, already had in their documentation when they ruled on this in June, unanimously, I would point out?
Commissioner Kelly.
Mr. Chairman and Senator Osmek, I will answer that question, but I think it's important for the committee to have some background. It is not unusual. It's not common, but it is not unusual for the department to appeal a Public Utilities Commission order. We've done that 6 times since 1987. 4 of those 6 appeals occurred under the administrations of Governor Pawlenty and Governor Carlson, and 2 were under the administration of Governor Perpich in the late 1980s. So it is not new that the department disagrees with the conclusions of the commission, and in this case, we felt that the order did not adequately take account of the department's concerns regarding the absence of a forward-looking demand forecast.
Senator Osmek.
And I'll finish, Chair Mahoney. Commissioner Kelly, I'm very, very disappointed in the department and the activity that's swirling around line 3. I don't believe that this appeal should be going on. That is something that the Senate has in its positions in this omnibus bill. That information was presented to the PUC. I have personally spoken with at least 2 commissioners. They indicated that everything that you are appealing now was in the original case, that this is nothing short of a waste of taxpayers' dollars. I'm sure you disagree with me, but I believe if this has already been adjudicated, it was adjudicated 5-0 with this information in June. There makes no sense whatsoever to have agencies suing themselves other than to make lawyers happy around the state capitol. So I respectfully disagree with this suit, and I hope that the Senate position is taken up in this omnibus bill. Thank you, Mr. Chair.
I think Representative Long had a question. We'll get to yours.
No, please.
Thank you, Mr. Chair. Commissioner Kelly, you got a chance to talk a little bit about the governor's priorities in the Conservation Improvement Program, which I know are one of the policy priorities in the energy space. And I'm wondering if you can elaborate on some of the other policy priorities of the governor's in the energy section of the bill.
Commissioner?
Mr. Chairman and Representative Long, the governor has proposed that the state of Minnesota commit itself to achieving 100% clean energy by 2050 and has proposed two methods that would help the state to get there. One method involves the modernization and what we think of as the optimization of the Conservation Improvement Program. And the second method is the proposal that's known as Clean Energy First that strongly favors renewable energy for new and replacement energy generating facilities in Minnesota. Those are the three key pieces. And I think given the letter that the legislature received recently from Minnesota businesses advocating movement towards decarbonization. And I know that the members of the legislature and others hear a lot from people who believe that they'll be in some way negatively affected by the energy transition, but I think it's just as important that we pay attention to the people who are becoming entrepreneurs, who are using the opportunity of the energy transition to make themselves, their communities, their organizations better off. And we need to pay as much attention to those folks as we do to the people who are concerned about potential harmful effects that they see. I think those are exaggerated. But you know, I had an opportunity to go to Mankato State a few weeks ago, and one of the students there was a veteran who was going to get his mechanical engineering degree, and he said that one of the reasons he wanted to do that is so that he could work with his family to add renewable energy to the family farm, because it was a crop that paid a lot more than their current crops. And there are numerous examples around the state of co-ops and other organizations that see the opportunity in moving forward on renewable energy. We should be doing what we can, and the governor proposes that we do what we can to support that forward movement that will prepare Minnesota for a different kind of competitive future, where in order to be competitive, Minnesota manufacturers will have to be able to tell Target that the products they propose to sell to Target were made in a sustainable fashion. Some of those small businesses don't have the same resources that General Mills or 3M or others have to go out and buy renewable energy credits or subscribe to a solar farm or enter into an independent power agreement. Those folks need to be in an energy system where all they have to do is say, I made my product in Minnesota, so by definition it's a clean product. That's the kind of opportunity that I think we can create for business people in Minnesota as more and more companies respond to consumer and employee requests that they move in the direction of sustainability and clean energy.
Representative Long.
Thank you, Mr. Chair. And the Commerce Department does closely follows the energy system of our state and weighs in front of the Public Utilities Commission on this often. How confident are you that we can get to 100% clean energy by 2050 affordably and reliably?
Commissioner Kelly.
Mr. Chairman and Representative Long, it would be wrong for me to claim that my crystal ball is error-free, but I would just turn, for example, to the state's largest utility that is confident for a significant portion of Minnesota's customers that it can achieve 100% clean energy by 2050 and do so reliably and affordably within the projected cost of living increases over the next 30 years. And I don't think they think that necessarily will be, smooth. There will be lumps in the process as they change from one plant to another source of energy, but they believe it's possible, and they've committed themselves to doing that, and I think we ought to take some confidence from that.
Representative Long.
Thank you, Mr. Chair. And you mentioned business opportunities, and just yesterday, the Public Utilities Commission unanimously approved the Google proposal, and I think that's a pretty good example of a company bringing tax revenue to the state, business, new jobs to the state because of the commitment of Minnesota companies to renewable energy and their ability to provide that renewable energy to Google. And I wondered if you had any insights from that process that you wanted to share.
Commissioner Kelly.
Mr. Chairman and Representative Long, well, first, it's the headline. That is that companies that are looking to invest in Minnesota do want clean energy. And it isn't just high-tech companies like Google, it's General Mills and 3M and other companies that are already invested here. And so I think as we look to attract new businesses to Minnesota, maybe additional data centers, they're not going to be looking for coal-based energy. They're going to be looking for clean energy. And I think creating a system that provides that, a company the scale of Google can go to Excel and work out some deals for how to acquire energy. But attracting small businesses that are interested in clean energy means that we've got to create an energy system that is sustainable so that those small businesses looking at investing in Minnesota don't have to cut a special deal in order to be able to say that their product or their service is produced sustainably.
Senator Pratt is going to pass. Representative Wagenius.
Thank you, and thank you, Commissioner. I appreciate your talking about how we want small businesses to be involved. But I am sensing that not everybody knows about the Google plan, and maybe if you could tell us a little bit more about the background and how you see that actually evolving, or not evolving, how that is a model for later.
Commissioner
Mr.
Kelly.
Chairman and Representative Wagenius, I'll be a little reticent about a couple things because the department has some non-public data with respect to that project. So here's my understanding, is that the Google data center, planned to be located near Becker, will, once fully implemented, be the state's single largest electric load. So I think people need to keep that in scale, that this is a significant new actor in our energy system, and that Excel has worked with Google to identify ways to produce additional wind resources that would provide enough power to fully power that new load despite its scale.
No, okay. The Senate is now under call. I had a couple of questions myself. Are you going to be available a little later this afternoon?
Mr. Chairman, at your disposition.
One of the first people who's ever said that to me. Typically, it's get your, never mind. So, Senator, I have a couple other questions. Do you have an idea when the Senate will be done on the floor?
It shouldn't take too long, Mr. Chair. I think we can continue, just to be aware that we may need to leave at some point in time.
Okay, all right. Seeing no other questions. Actually, I end up with the Jobs Committee, I end up having to listen to people talk about stakeholders and how many there are and a variety of other pieces as they try to negotiate something. So I want to go back to the unclaimed property. You, in your testimony, you talked about one or two still having some concerns in the stakeholders. couple of questions here. How many stakeholders did you start with? How many issues did you start with? And now that you're just down to 2 stakeholders, how many issues are left?
So,
You've got a friend in the audience if you need help, I know.
yes, I understand that, Mr. Chairman. Though they do expect me to do some of my own work. So,
Not my staff.
Mr. Chairman, we, particularly with respect to the number of institutions that hold or could hold unclaimed property, it's a very large number of stakeholders, but we work primarily through the associations that represent those stakeholders. So it's a much more limited group of people that we have worked with. And at the outset, when we proposed the language, I would say that lots of issues were involved in understanding that language and how the pieces fit together. The new language contains a lot of new definitions, and then how those definitions interact with actually how we work with the holders of potentially unclaimed property to identify property that should be returned to the state so that we can look for the legitimate owners of that property. And so I would say that we continue to work with all of those association stakeholders, and that they've narrowed in on a couple of issues. But what I want to go back to a point that Senator Dahms mentioned. There is no opposition or controversy related to the need to include, before the legislature adjourns this year, some language related to authorizing us to pay interest on claims that arise from interest-bearing accounts. Nobody has any controversy about that. So that we think can happen. The stakeholders have not raised any concern about our proposed staffing changes with respect to this, and they haven't raised any concerns about our desire to get funding for a new operating system that will handle these activities in a better and more secure way. So those 3 pieces are for sure not controversial. I think the good news from my point of view is that despite the fact that this is a significant change, we have been able to work with the stakeholders to narrow the concerns on broader aspects of the bill. And my expectation is that we'll continue to do that up until the point where the legislature says we need to know now, and I need to tell you whether it's still controversial or not.
Thank you. You kind of took care of my next question. What do you need this year passed? And it sounds like operating system, staff, and the other.
Correct.
Thank you.
Mr. Chairman.
No. Senator Pratt.
Well, thank you, Mr. Chair, and I was going to kind of stay out of this, but maybe I'll jump in. We've been working on this unclaimed property now for a couple of months since it was first presented in Commerce Committee, and it seems to me that your opening testimony was thanking the House for including the policy that quite honestly had a lot of problems with it. And I recall Mr. Brickwitty saying in the Senate Commerce Committee that, we would continue to work on this through the interim. I don't see necessarily the rush to implement a policy that, as Senator Dahms said, could have many unintended consequences. And so can you clarify your thoughts on that from your opening remarks to some of your more recent remarks in this committee today?
Commissioner Kelly.
Well, Mr. Chairman and Senator Pratt, when I testified on this subject previously, I don't think I mentioned working on it through the interim. I did say that we would work with stakeholders to achieve consensus. And I am acknowledging to this committee that we have not achieved complete consensus, though I'm really pleased with the progress that we've made with the stakeholders and how apparently narrow the remaining issues are. And I will say that when I was in a different position, I could have been accused of introducing an incompletely thought-through piece of legislation, and appreciated the opportunity to work with stakeholders through the legislative session to try to achieve a mutually acceptable result at the end of the legislative session. And now that I'm sitting in a different position, I continue to have the same view that it's valuable to work with stakeholders to try to get to a conclusion and to use the good work that the legislature does during this session as a way of moving that agenda forward. It is possible that we will not have the kind of consensus that we intended to have when I first appeared, and in that case, we will be back in front of the committee acknowledging that fact. But right now, I'm not in a position to say that we cannot achieve that degree of consensus that my expectation was at the beginning.
Senator Pratt.
Well, thank you, Commissioner. And I guess I was confused because I thought you were supporting the language in the House bill before you had gone through that. But I wanted to follow up on some of Senator Osmek's comments. And I made a note of something you said, that the lawsuits that you were doing were necessary work of the department. We owe Safelight nearly $1 million. We owe North Dakota over $1 million. Roughly $2 million of this budget that you've requested is going to legal fees that your department has lost the case. And whether you've negotiated lower legal fees or not, they're still the monies of the people of Minnesota. And now here we are going down a lawsuit, and I don't know if there's a question here as much as an opinion. And your department doesn't have a very good track record in recent years. And you can say that this was inherited from the previous administration, but right now, Commissioner, you and the governor own this. This lawsuit is whether or not you want to pursue it. And I quite honestly, when I look at the need for the pipeline, that it's 60-year-old technology that's running at half capacity. Chair Mahoney and I did a joint press conference a couple of years ago encouraging approval of this. I would really ask you and the governor to rethink this position. Let's not waste the taxpayers' money. Let's take this lower emission option, right? Because the option is putting this thing on freight trains, which is less safe and emits more carbon, which you're presumably, as we've been working on energy stuff for the last couple of years, is one of your key points. I just don't see, other than to satisfy some sort of political agenda, any reasonable way that this needs to be continued. And so I would encourage you and the governor to immediately cease this endeavor.
See, who said Senator Pratt and I can't agree on something? Commissioner Kelly, would you like to respond?
Mr. Chairman and Senator Pratt, those messages have been received, and I will just say I have tried to think about this. I did try to put my conservative hat on and think about this from a more conservative point of view. And one thing I'd like to point out in connection with that is that when the Public Utilities Commission grants a certificate of need for an undertaking like a pipeline, and then also approves a related route permit and environmental impact statement, it is giving a private party the right of eminent domain to take people's land in pursuit of that project. And so from my point of view, it's an entirely conservative point of view to say that before we authorize a private party to take private land for a project of this type, that they ought to have demonstrated the need for it. And that is what a certificate of need proceeding is all about. And that is one of the reasons that the department has taken this position with respect to a forward-looking demand forecast that helps to explain the need for a project like this.
Senator Dahms.
Well, thank you, Chair Mahoney and Commissioner. I'm going to change gears here a little bit back to unclaimed property. First of all, thank you for working with the stakeholders to get to the point you are today. But I do think maybe you're taking it a little too lightly as to how much is left to do and how many problems there still are out there. I've talked to several stakeholders in the last week, week and a half, and trust me, there's still a lot of angst, still a lot of concern about this, and it's not ready for prime time. So I hope that your seriousness with this continues as it has so far in the past, and that we get these things worked out. And if we have to go to next year, again, I say we need to do that versus put something out this year that we have to try to come back and fix after we've made a lot of mistakes. So just wanted to make, for the record, make sure that that statement was made.
Mr. Chairman and Senator Dahms, for the record, I think that the team at Commerce has been working hard, but if you talk to any stakeholders who feel that they have not been adequately heard, they should contact me directly so that we make sure that their concerns get heard.
Follow up, Mr. Chair.
Go right ahead, Senator.
Thank you, Chair Mahoney and Commissioner. I haven't had anybody, stakeholders, tell me they haven't been heard, but I've had some say the results of what they said hadn't been handled. So there is a difference, but you may be hearing the people, but we may not be moving forward to what the majority of the people that you're hearing from would like you to do and would probably be the proper to do. Thank you.
Are there any other questions for the Commissioner? Senator Pratt.
Thank you, Mr. Chair. I guess I had a follow-up, so this, to me, this doesn't feel like a conservative, progressive argument, right? I guess the argument would, and so maybe you can help me understand on this lawsuit, right? Because this isn't about being conservative. This is about being responsible, and as we often talk about here, good stewards of the resources the people of Minnesota have granted us to do. So is this just a procedural lawsuit, or does the governor really want to block the development of this? What do you and your department, what's the end goal here? Why are you doing this?
Commissioner Kelly.
Mr. Chairman and Senator Pratt, I'm going to risk repeating myself, and by doing that, I'm not trying to be disrespectful. The department's lawsuit is based on a conviction that state law requires the submission of a forward-looking demand forecast in a certificate of need proceeding, and that what the applicant in this case submitted was not a forward-looking demand forecast. And so we have appealed with that very narrow issue in mind, which is that before a large energy project of this type goes forward, there needs to be a forward-looking demand forecast. And that is it as far as the Department of Commerce is concerned.
Senator Pratt.
Thank you, Mr. Chair. I guess it really doesn't answer my question and what the end goal is. Certainly, the PUC issued the certificate of need. Your concerns were considered. The only thing I can presume is that it's the desire of you and the governor to stop construction of the pipeline. Is that correct?
Commissioner Kelly.
Mr. Chairman and Senator Pratt, the department's objective is to stand up for the provision in state law that says that there needs to be a forward-looking demand forecast, and that is an important consideration in a certificate of need, because if the applicant doesn't prove that we need the product of this facility, they have not met the requirements of state law. So, Mr. Chairman and Senator Pratt, I mean, one option open to the legislature is to change that portion of state law, but since it's there, we think it's our responsibility to stand up for that portion of law.
Senator Osmek.
Thank you, Mr. Chair. So Commissioner Kelly, could you please highlight for us what section of law you're referring to that requires this demand forecast?
Commissioner Kelly.
So, Mr. Chairman and Senator Osmek, I don't have that
You
particular.
don't have that section memorized?
I have not gotten that statute memorized, but it is there, Senator Osmek. I've read it multiple times since starting this job at the beginning of January. And I've also read the similar rule provision. And I acknowledge that the commission thought this was a close question, at least by their order, because there's a portion of their order that says that they have what, in our experts' view and the department's view, was submitted was a supply forecast rather than a demand forecast. And we can see from the applicant's point of view why a supply forecast might be relevant to them, because they're trying to move oil from one place to another, and if there's a large supply of oil in one place, they want to move it. But that is not the concern expressed by the legislature in the statute. The statute says, is there a demand? And so we expressed during the proceedings and have continued to express that a supply forecast is not a demand forecast.
Senator Osmek.
Thank you, Mr. Chair. One follow-up question. Commissioner Kelly, you indicated during the discussion, during your comments about eminent domain. Refresh our memories. How many miles or how many feet of eminent domain, new eminent domain, is going to be required for this line? I know that originally the original plat went around the tribal nation, but now I believe the final platting of this went through and is in the same trench and in the same area, where I don't know if there's necessarily a lot of, not in the exact same trench, but I believe it going into the same area where there's no additional eminent domain required. Am I correct or am I wrong?
Commissioner Kelly.
Mr. Chairman and Senator Osmek, there is a portion of the approved route that is not in the same footprint as a previously approved route. So new land acquisition, as I understand it, is necessary. Now, what I don't know is the extent to which Enbridge or the particular applicant has been able to negotiate land purchases. And so when I made my point about eminent domain, it wasn't so much about this particular project and the extent to which eminent domain might be necessary, but the precedent about which we're concerned, which is that some future project that could be approved without a required forecast of future demand could involve eminent domain, and that we ought all to be concerned about the circumstances under which a private party gets access to the power of eminent domain.
Well, thank you, Commissioner Kelly. I suggest that your crystal ball appears to be working again, because now you're crystal balling forward in time into the future what may or may not happen. My understanding is that there is no eminent domain whatsoever required to make the replacement of Line 3 go, that they actually have all land under purchase agreements, and that what you're doing is speculating on a possible position that may happen or may never happen in the future. So as Senator Pratt has indicated, I have the same very serious concerns that we are expending taxpayers' dollars on an intramural, I'll call it that, an intramural lawsuit that only makes lawyers in St. Paul happy. And I'll leave it at that. Thank you, Mr. Chair.
Thank you. I want to make one thing clear here as concerns to Senator Pratt's comments. And though I have made my position clear for a very long time on the Line 3, and one of the concerns is that it is on a rail line, and it's a rail line that goes directly through my particular legislative district and puts about 15,000 people at risk of an accident. I have never heard the governor or his staff say that they are against Line 3. Never seen it in print. I've never seen it. I've never heard it on a private conversation or a public conversation. The governor, for all intents and purposes, I'll use language that I would use on a job site. It's just a process, and we're going through it. As much as I don't like the process, the governor has never said he's against this particular line. And understand some of this conversation is why my pipe fitters local union had 7 people with their JD, and they said, never will I ever go into a courtroom. They became pipe fitters and stayed pipe fitters for 40 years. Representative Long.
Thank you, Mr. Chair. Just to follow up on your comments, I think that while we may have individual opinions about the project as a whole, the question I think before us is the process. And as the commissioner pointed out, there have been a number of instances where the Commerce Department has disagreed with the PUC. The Commerce Department is an independent body and gets to make its own assessment. And I was just curious, you may not be able to answer this, but if the shoe were on the other foot, and if the Public Utilities Commission had felt that the demand forecast was adequate, and you all had felt that it was inadequate, do you think that, excuse me, other way around. If the Public Utilities Commission had felt that the forecast was inadequate and you all had felt that it was adequate, do you feel that the lawsuit might be continuing in this circumstance and we might have switched sides and had folks on the other side arguing that you needed to move forward with a lawsuit pronto?
Mr. Chairman and Representative Long, that's a tough hypothetical to answer because I don't know that the department would be, I think that one of the questions is where does the irreparable harm occur? And I don't know that the department would be in the position of arguing that we should go ahead and construct something if there was a risk that it was not needed. But that would be a hard thing. But what I can say is that I did serve in the legislature for 14 years, and I did not during that time ever see the legislature attempt to remove funding from a state agency. And I was in during the time when Governor Carlson and Governor Pawlenty and Governor Ventura were in office, and the legislature never once during those 14 years proposed to take away funding from a state agency for continuing a position that it was taking in its responsibility area.
Senator Pratt.
Well, thank you, Mr. Chair, and if Representative Long, I think in response to your comments, this, I would presume, again, I'll use that word, presume that the department is looking at the likelihood of success in a lawsuit. And the record of this Commerce Department and the previous Commerce Department is not good. In this budget, we're asking the taxpayers to pick up $2 million in additional legal fees that they've lost and owe to other parties. And all I can see here is that we're going to be, we've got one government entity suing another, and we're going to be back here in 2 years because the department's going to say now we owe our legal fees plus the PUC's legal fees, and our taxpayers are stuck paying the bill. And I would just ask, I think the department's going down a bad road that they're likely going to lose, and because their recent track record would suggest that they are going to lose. And we've right now, North Dakota's got $5 million stashed away in a defense fund, and every time we go off and sue them, they're going to be using our own money against us. So I would hope that we could just move this along. If a private party wants to challenge the process, the private party can challenge the process. But I still am not sure what the objective of this lawsuit is, and it just seems like a complete waste of money and time.
Senator Simon.
Thank you, Mr. Chair, and this is, I don't know, I kind of debated whether I should weigh in on this or not, but obviously I chose to. Commissioner, I'll have a question for you, and then I want to make some general comments. You and I have talked offline about the Line 3 project, and I think you understand where I'm at in terms of supporting the project. But I think it's important, because I haven't heard it brought up here yet today, and I think it's important that all of the committee understands and knows, as well as the members of the public that are watching as well. And maybe you can just reaffirm what I believe to be true, in that as this lawsuit moves forward. At the same time, the permitting process for Line 3 continues and has not been interrupted by the filing of this lawsuit. So in theory, if the department loses the lawsuit, those permits will be issued at the same time as if there had been no lawsuit filed.
Commissioner Kelly.
Mr. Chairman and Senator Simonson, my understanding is that the two other responsible departments are the Department of Natural Resources and the Minnesota Pollution Control Agency, and that their activities with respect to permitting are continuing, and that they are not waiting until the resolution of this lawsuit.
Mr. Chair.
Senator Simonson.
Thank you, Mr. Chair, and thank you, Commissioner. I think that's just an important point for folks to understand and recognize. And, you know, I'm sure that we could go on and on, back and forth about whether we should or shouldn't, and I generally agree with the Senate position on this. But that aside, let me just make another comment as long as I have the floor. I'm a little bit concerned about time. It's Wednesday, which means Monday is coming sooner than later. And if we don't start to make some movement soon, my concern is that we will lose control of this process. And by we, I mean us as committee members. And that scares me a little bit, because there is a lot of good energy and jobs and commerce provisions in the Senate bill. And I'm sure there are many good provisions in the House side too. But specific to energy, let me just make this point. I think the Senate consciously made the decision to take the discussion around changes to the RES or to the carbon standard and push it off into the interim. Not because we're trying to delay it, but because we think that it's worthy of a broader discussion between House and Senate members of the LEC. And I think that there are a lot of nuances to that discussion that we want to have. So in the event that this bill ends up at a higher level out of our control, I hope that you will consider that provision, because I think, and I can't speak for everybody, but me personally, I want to have that discussion. And I think it's an important discussion that we have collectively, not just independently of either body. Definitely worth a broader discussion. And the last thing that I'll point out is this, is that as we talk about increasing the renewable energy standard, or the Clean Energy First provision, and I know that there's been a lot of off-ramps kind of built into that policy. It just makes me pause a little bit and wonder if we're going to institute a policy of that significance with as many off-ramps as we built into it. Perhaps it's not the best policy yet. But that being said, I will just point this out, because I don't see anybody else around this table from northern Minnesota. And you know this as well as anybody, Commissioner, that northern Minnesota and the IOU that represents many of us in northern Minnesota is unique. 60% of Minnesota Power revenue comes from 12 customers. These are high energy users, large power users, and we want to make sure that as we move forward with energy policy, that we're respectful of that. I certainly understand the argument about the clean energy jobs and how that sector is growing, and I think that's wonderful as long as we do it right. But I also think we have to be respectful of the jobs that we have currently and make sure that we're not making decisions that drive them in a direction that we don't want them to go. But at the very least, please consider that as this moves forward, that we want to have a broader discussion, I think, in the LEC about what our next big energy steps are.
Do you wish to make a comment to that?
Mr. Chairman, no.
Are there any other questions or comments? Any other questions or comments? Well, I have one. My staff has urged me to make one last attempt at the wage theft negotiations that ended on Friday. But I give you that in writing. I'll let you take a look at it, and we can talk a little later.
Thank you, Mr. Chair.
We stand, because there is still a glimmer of hope that there may be some deal soon. Now, that'll start a rumor. I'm going to recess the committee to the call of the chair. If we don't really see any light somebody said white smoke coming out of the Capitol by 8 or 9 o'clock tonight. Believe me, we're not coming back, and you'll have the gavel tomorrow. So with that, we stand in recess.